Hello and welcome everyone to the Introduction to the Law of the Sea. I am Muhammad Tahmidul Islam, lecturer, Department of Law, World University of Bangladesh, and I will be presenting you this presentation. Okay, our contents of this lecture are the Introduction to the Law of the Sea. So first we are going to talk about the basics of the Law of the Sea, and then we are going to talk a little bit about the functions of the Law of the Sea, how the law operates, and what are its contents. So let's begin. The introduction. International law of the sea is the system of international rules governing the extent of a coastal state's sovereignty on the sea, the rights and obligations of a coastal state, and other subjects of an international law of the sea. Their mutual relations regarding the exploration and exploitation of living and non-living resources of the sea and seabed, their duties concerning the protection of the marine environment from pollution, and many other rights and obligations. So from this part we can understand that international law of the sea is a vast area of law which is primarily concerned with the state rights relating to the seas and everything that is in the sea, the natural resources, and how the countries or the states use the seabed and the resources that are found in the sea. It is a body of international law that concerns the principles and rules by which public entities, especially states, interact in maritime matters, including navigational rights, sea mineral rights, and coastal waters jurisdiction. So there are a lot of legal jargons which are unique to the international law of the sea, and these legal terms are going to be explained in the later lectures. So if you do not understand any of the terms that are being said here, do not be concerned. These terms will be explained. So in this point, what it means is that in usual, international law of the sea is part of the international law, the public side of the international law. It is the public international law part because it mostly touches on the subject of the state and its international relations between the states. So that is why it is almost entirely on the side of the public international law. Contrasts to maritime law and national law of the sea. The international law of the sea does not belong to the body of national law, but instead represented a territory and usage-oriented branch of public international law. So it is a part of public international law, and for many states that have sea boundaries, they can have their own national laws regarding the usage of the seabed and the usage of the sea resources of their own country, and that falls within the national law. But international law of the sea is such a type of international law which applies to all the countries that have any boundary with maritime water, and even if they do not have any boundary with any sea, when they are traversing on the sea, they have to abide by the international law of the sea. The subject matter includes, on the one hand, the different maritime spaces, zones, and boundaries, that is, the legal provisions which define and divide the oceans, the seabed, and the maritime airspace. And on the other hand, the international law of the sea also contains the regimes concerning marine scientific research, as well as usage and protection of the ocean and its resources. So, firstly, the main subject matter of the international law of the sea is that the delimitation of the borders or boundaries, because seas also have a certain degree of boundary in which the states control their jurisdiction, their power, their laws. And secondly, the subject matter is the using the resources of the international law of the sea, which is the marine scientific research and the protection of ocean resources, ocean life, etc. Now let's talk about the functions of the law of the sea. The law of the sea plays a dual role in international relations. First, the primary function of international law involves the spatial distribution of jurisdiction of states, and the same applies to the law of the sea. So, going back to the first element of the international law of the sea, the main focus or the main function is to delimit the national boundaries of the national jurisdictions. And the contemporary international law of the sea divides the ocean into multiple jurisdictional zones, such as internal waters, territorial seas, the contiguous zone, the exclusive economic zone or EEZ, archipelagic waters, the continental shelf, and the high seas. So all of these terms, we are going to talk about these terms in the later lectures, so do not worry. So these are all zones and different areas of the international sea, where states have different level of authority to exercise their laws and their powers. In principle, the law of the sea provides the rights and obligations of a coastal state and third states according to these jurisdictional zones. So, law of the sea actually provides a guideline on how to interact with third parties regarding the international law of the sea. Consequently, the law seeks to coordinate the interest of individual state. This approach is sometimes called the zonal management approach. So international law of the sea actually takes a zonal management approach in which it tries to consolidate, and it actually tries to create a harmony between the states in exercising their jurisdiction, because there are a lot of states, many states, they have shared boundaries with the international sea. So there can arise certain level of tension, certain level of misunderstanding between these countries, that how they are going to use their sea. So international law of the sea actually creates a harmony between the states in zonal management approach. So considering that the world is divided into sovereign states, the traditional role of the law of the sea will in no way lose its importance. Second, given that the ocean is one unit in a physical sense, the proper management of the oceans necessitates international cooperation between states. So it needs no more explanation, I think, because sea or international sea is such a vast region of the world, because land mass is only 1/3 and 2/3 of the actual area of the planet Earth is covered by sea. So from that we can understand how important it is, and how important it is to have an international rule to delimit the state powers and to define the state powers and how they can interact with each other in times of war, in times of in times of peace, when they're doing business, when they're doing scientific research, and etc. In general, the spatial scope of man-made jurisdictional zones does not always correspond to marine ecosystem. So marine ecosystem is a unique thing, because it does not follow any country's boundaries. So if one country does some act or does some economic activity that harms the marine ecosystem, it will have a detrimental effect to the neighboring country marine ecosystem as well. So that is why we need the proper implementation and adherence to international law of the sea. In fact, several species, such as straddling and highly migratory species, do not respect artificial delimitation lines. The divergence between the law and nature is a serious deficiency in the traditional zonal management approach. International cooperation is thus a prerequisite for conservation of marine living resources as well as biological diversity. So from that we can understand that marine species, or the fishes and the ecosystem that are under the international sea, most of them are not yet discovered. It is said that we have only discovered somewhat like 5 to 10% of marine life. So a vast majority of the marine life is already, without outside of our knowledge. So we need to do scientific research to understand them, uh, to learn more about them, how they live, and etc. However, we also have to understand that in our pursuit of understanding how the marine ecosystem works, we need to be respectful of how they live, or respectful and be conscious about our activities that are detrimental to their lives. Similarly, without international cooperation, the regulation of marine pollution would be less effective, because pollution may spread beyond maritime boundaries. Yes, pollution can, and usually it does spread beyond maritime boundaries, because boundaries are not, sea boundaries are not something where you can put a wall and then say, yes, we are actually, protected. We cannot be protected by erecting a wall on the sea. So seas do not have walls, so pollution can spread, and it does spread. That is why we need to approach it holistically, approach it together with many states. Furthermore, a single state's regulation of industrial activities to prevent marine pollution would put that state's economy at a competitive disadvantage. So this is also a certain thing about the environmental pollution. If the environment of one state is in danger, another state also falls victim. And if one state does everything to protect the environment, and other states do not, then the state that is uh, enacting all those rules and preventing itself from the destruction of the environment, that country is actually at a competitive disadvantage when it comes to economies. So we need to approach it holistically. We need to approach the problem, we need to approach the issue in such a way that every country is implementing the same type of rules, so that everyone is at the same footing. And international cooperation is also needed in marine scientific research due to the highly complex nature of the ocean. The law of the sea provides the legal framework for ensuring international cooperation in marine affairs, thereby safeguarding the common interest of the international community as a whole. So that is actually the main target of the international law of the sea. It has to provide a legal framework for every country to follow, so that we can use the natural resources that come from the international seas, and we can protect the international sea life, so that our future generation can learn more about it and understand it, and our lives are enriched in the process. So thank you all for participating in today's lecture. I hope you have enjoyed the lecture and learned something from it. If you find anything difficult to understand, please ask in the comment section. I will answer accordingly, and I hope to see you in the next lecture. Thank you all.